So I'm very happy that Sophia, very much unlike what very often happens in the social sciences, when we talk about rights, we forget that there's this little discipline called law that has somewhat of a contribution to about that particular issue. So I'm very happy that Sophia remembered this. So in this session we have two very foremost lawyers. We'll be talking about this generic theme, rights and the law. So Miguel Nogueira de Brito is a PhD in law of the University of Lisbon, where he also teaches and conducts research. He is one of the main experts in this country in administrative law. He was a member of the Superior Council of the Administrative and Fiscal Courts. But we know him mostly for a somewhat different, although in some aspects related, contribution, his work on political philosophy and the philosophy of law, where he has published a number of studies. We are short in time, so I'm not going to make the full list. Let me also mention that Miguel was a legal clerk in the Constitutional Court, which is a profession that tends to produce some of the best constitutional lawyers in this country. So he's not an exception. We also have Margarida Lima Rego. Margarida Lima Rego teaches at the Nova University of Lisbon at the law faculty, and she's also a senior lawyer at one of the most important law firms in Lisbon and in the country. She also has a very important role in the Nova doctoral program in law, and she is an expert in corporate and commercial law. And she also has had important roles in drafting or helping drafting legislation in the field of insurance law in her capacity as advisor to the Portuguese government. So the first we'll be talking will be Miguel, and the theme of his talk, the title of his talk is Are Social Rights More Like Civil or Political Rights? Miguel.
Thank you, Pedro. Thank you. Good afternoon to all. First of all, I would like to thank ICS and Sofia Abuin for having the nerve to invite a lawyer to speak among economists and sociologists. And this is, in a sense, ironic, because I will end by saying that law is only a part, although an important part, I think, to answer the problems that are involved in the enforcement of social rights. Difference in the legal treatment of social rights are well known. Some constitutions do not include social and economic rights at all, like the German Constitution. Other constitutions, like the Indian Constitution, state that such rights, social rights, are not enforceable by courts, even if the state has the duty to take them into account in the making of laws. Other constitutions, like the Portuguese Constitution, contain a generous provision of social and economic rights. Perhaps the Portuguese Constitution is the most complete constitution in what regards social rights, but does not confer them the same juridical force it established for classic liberal rights. And finally, other constitutions, like the Brazilian Constitution, which is perhaps the only more developed constitution concerning social rights than the Portuguese one, considers social rights on a par with liberal rights, granting them the same juridical force. In contrast with this situation, there is a considerable homogeneity regarding the legal treatment of the so-called liberal rights, in the sense that all constitutions recognize them in the same legal force without relevant variations. There are many explanations to these contrasts. First of all, social rights are understood as second-generation rights on the face of liberty rights, a qualification which implies a secondary character also in terms of legal force and priority. Second, social rights are considered as requiring positive action from the state, and they involve a significant amount of public expenditure. And third, social rights are usually seen as an inappropriate for judicial enforcement. I think these are all, at best, circumstantial explanations which can't resist a critical examination. But before going to that, I think it is important to stress that there are in our current financial state of emergency, there are two radical different perspectives on the issue of social rights. And they are equally dangerous on my view. On the one hand, we have the neoliberal perspective. Effective social installments are dependent upon the health of a country, and they should be seen as far as possible integrated in a system of private charity. On the other hand, we have, on the opposite side, we have what might be called the proprietary perspective in the line of Charles Rice's New Property, for which social rights are enforceable as property rights and as individualistic as these. I think that in each perspective we miss an important dimension of social rights. The neoliberal vision misses the obvious point that social rights are a matter of justice, not charity. The proprietary vision misses the solidarity dimension of social rights. But most importantly, these two perspectives are the two sides of the same coin. This is the neoliberal primacy of economic life over all other dimensions of social and political life. I propose to explore the risks of ignoring this political dimension of social rights as a consequence of the risks of centering the enhancement of the protection of social rights by means only of the action of the courts. Having outlined my intention, I must now formulate the dilemma concerning economic and social rights. On the one hand, it makes no sense, as we shall see briefly, to insist on an essentialist version of the distinction between classical liberty rights and social rights. But on the other hand, if we dismiss all distinctions in the domains of constitutional rights, we run the risk of ending in a situation in which all we have is individualist rights talks without the slightest understanding of the political and economic problems that must be considered in the enforcement of social rights. If all rights are equally justiciable, judicially enforceable, then they all necessarily are, in one way or another, instruments in the pursuit of individual interests. Let me illustrate this dilemma with three problems. First of all, the problem of competition. If social rights are judicially enforceable, just like any other liberty right, it looks plausible, however, that the courts are more apt to preserve the economic order implied in the liberty rights than in implementing a new economic order in which social rights make sense. A clear illustration of this problem, this competition problem, is the case of South Africa. The South Africa Constitution has legitimated the entrenchment of social rights. But it has also, at the same time, and in a kind of trade-off, legitimated the entrenchment of apartheid property gains. In this way, we can say that economic and mostly white elites have managed to preserve their power through the courts and through the enforcement of liberty and civil rights. At the same time, the opening of South Africa to economic globalization has introduced privatization, deregulation, the abandonment of the management of the economic life exclusively to the market, but also to street crime. Second, we have another problem, the problem of substitution. This occurs whenever the courts adopt an assertive role in social rights adjudication, substituting their preference for those of the political branches. This is illustrated by the case of Brazil. In Brazil, there is empirical data showing that health litigation, in special, has clearly not benefited the poor. It has by and large benefited a minority of individuals who are able to access lawyers and to access courts to force the state to provide expensive treatment that the public health system could not provide in any plausible interpretation of what the Constitution says about health rights. The numbers are in fact impressive. In a recent study of litigation against the federal government, it was found that of about 4,000 accumulated lawsuits during the year from 2005 to 2009, 85% originated in the most developed states in the south of Brazil, even though their population represents just about 50% of the country's total population. And finally, there is a third problem, the problem of judicial insulation. This appears to be the present case in Portugal with the so-called reform of the welfare state and the decisions of the Constitutional Court on this matter. The public opinion discusses intensely the decisions of the Constitutional Court concerning legislative statutes that introduce, for example, cuts on social security, pensions and allowance, but these discussions are centered exclusively on the supposed rights of the pensioners, on the violation of their trust on the system. We have no signs of a serious public discussion concerning the system's sustainability, the perspective of the principle of the justice between generations. This, in fact, has not been heard in the public discussion. These problems are not meant, don't get me wrong, to uphold the traditional separation between classical rights, liberty rights, and social rights. In fact, I think this separation is not viable, and I give only two examples. First, many critics maintain that civil and political rights are negative rights, while social rights are positive rights. And this has a consequence, according to these critics. They say that negative rights are rights against government interference, while positive rights are rights to government help, or, more precisely, rights to some action by the state in the areas of health care, education, social security, labor, etc. Now, it is easy to identify an action that violates a negative right. It's simply the action the state should have omitted. On the contrary, in the case of positive rights, there is more than one alternative action the state can perform in order to not to violate the right. The problem with this distinction is that it does not fit the division between classic liberty rights and social rights. Some classic rights involve positive actions by the state, and some social rights are rights against government interference. I give you two examples of this. First, the Portuguese Constitutional Court has decided that a legal statute that allowed the judicial seizure of a social allowance equivalent to the Portuguese minimum wage was unconstitutional by violation of the principle of human dignity and the right to social security. This is clearly a negative dimension of a social right. An even clearer example is property rights. Private property depends on property rights, and this does not exist without government and without law. In fact, the government is needed both to create the system of property rights and to police it. Another distinction that does not hold is the view according to which social rights involve distribution concerns that are absent from classical liberty rights. This is simply not true if we see some examples. For example, it has been demonstrated that only in 1992, direct expenditures in the United States for police protection devoted to protecting private property ran to some $63 billion, and this is not an isolated case in the list of costly rights. So we can say that not only social rights but also classic liberty rights involve complicated matters of public expenditure. Even if this traditional distinction between social rights on the one hand and liberty rights on the other hand does not hold, it is true that they have a different reception of a problem that is common to all rights. This is the distinction we could establish between thin and thick versions of rights. Thin versions are the ones that are truly shared by all people, or are at least visions centered on rights that can seriously claim universality. This is undoubtedly the case of rights to human dignity, to freedom, which make torture, for example, or the persecution of political and religious dissidents unjustified violations of human rights. But on the other hand, a thick reading of rights is present if we consider a generous welfare policy. On a certain view, this policy can be presented as required by social rights, but on another view, it can also be presented as a violation of the ethos of liberty and personal responsibility. The point of all this is to stress that when a specific alleged implication of a social rights falls within a thin reading, it should be considered a judicial enforceable social right. On the contrary, if it belongs to the thick vision, it appears that the political system has more liberty in regulating it. Now, it is certainly true that the distinction between thin and thick readings of rights is generally applicable to all human rights, whether these are liberty or social rights. But this distinction has a particular name in the realm of social rights. This is the right to a social minimum, to a minimum of existence in dignity conditions. So the courts should only concern themselves with enforcing the minimum core of social rights. All specifications of social rights that reach beyond the minimum should be left to political and democratic deliberation. In view of this, it can be, we can say that just as the judicial enforceability of social rights entails the risk of an excessive individualistic understanding of these rights, it also leads to a minimum core reading of social rights. There are several problems with the concept of minimum. I shall not enter into this, but I think there is one point that is important to stress. We can say, on the one hand, that the minimum concept, being incommensurable with economic vocabularies, seems apt to confront the assumptions of neoliberalism. But on the other hand, it is undeniable that the claim for the minimum being made in order to increase the bundles of commodities of the disadvantaged fails to challenge the underlying economic institutions that have produced the situation of disadvantage in the first place. So one must take in consideration that in a neoliberal regime, the effect of a minimum, for example, a minimum wage, might be to subsidize employers of low wage and temporary labor. In a social democratic regime, on the contrary, the effect of a minimum might be to alter the balance of power between labor and capital. In any case, I think that the judicial setting out of the minimum bundles of commodities or entitlements is a poor alternative to the establishment of a framework protective of social rights that involves all branches of government. And so I have reached an impasse. I want to put away the view according to which social rights are minor or secondary or have a secondary status as human and constitutional rights. At the same time, we perceive the fragilities of rights talks in the domain of social rights. These are the mentioned problems of competition, substitution, and judicial isolation, as well as the problems of regarding the minimum definition of social rights. So I think that leaving the enforcement of social rights, just like any other human rights, primarily to the courts, is perhaps the most effective and powerful weapon of a neoliberal vision of rights today. What I want to emphasize is that the full justiciability of social rights is not required by their quality of full human rights. I want to stress that there are other dimensions of social rights to which the courts are foreigner. And to understand this, we have to understand that there are in fact various distinctions on the realm of human rights. Human rights are not all the same. A civil right, for example, has different formal properties from political rights. Civil right, like the freedom of thought or the freedom of reunion, begins as a claim of worth in the right bearer. A political right, on the contrary, begins as a claim of authority by someone different from the right bearer. So we can say that whereas a civil right precedes the duty to respect it, a political right is preceded by a prior duty on authority to conform to the concept of a valid and democratic authority. We can say that civil rights are agent-based and held against anyone, whereas political rights come with a certain status, permanent resident, citizen, and are held against particular authorities. And what about social rights? Are they more agent-based like civil rights or more status-based like political rights? I think that social rights have in common with political rights the fact that they both belong to a constitution of equality. They are both engendered by the egalitarian principle, not by a liberty principle, as is the case with the civil rights. A first implication of this is that since there is reasonable disagreement on the content of the affirmative duty of the state to create the conditions of self-authorship that are essential to social rights, the courts cannot simply substitute their opinion on social justice for the legislature's opinion. But a second implication would be to say that the bearers, the holders of social rights are themselves parts of the political culture whose participants reasonably disagree on the content of the social rights. And this, I think, has a further implication in the way we think between the connection of the enforcement of social rights and the way we think about citizenship. Traditionally, citizenship is conceived on a proprietary basis. We have jus sanguinis, according to which citizenship is conferred on a more or less genealogical basis, and we have jus soli, in which terms a person is a citizen of a certain state if he happens to born in the territory of the country in question. Actually, most countries combine those two criteria in order to exclude most unwelcome aliens. And this happens because citizenship is the door to welfare, is one of the doors to welfare benefits. So perhaps one of our efforts would be to discuss a different basis for attributing citizenship. One possibility of this would be to think of a jus nexi, that is a form of attributing citizenship not to be conceived as the recent Portuguese golden visa, but as a way to secure a solid connection between citizenship and effective participation in a political culture of which social rights are part. And thank you.
Thank you.
Thank you, Pedro. Thank you, Sophia and ICS, for this invitation. I'm very honored to be here. And getting to the point, because it's getting late. I'm here to talk about statistics as a basis for discrimination in the insurance business. All persons should be treated as equals. This means that as individuals, each of us should be treated with an equal measure of concern and respect. It does not mean that we should all be given the same treatment in spite of our differences. Treating persons as equals may call for different treatment or unequal treatment when their starting point is different. So the principle of equality should not be regarded as a ban on differentiation, on the recognition of individual differences, nor should it be seen as a ban on generalization, on the disregard for individual differences. There is no rule-making without generalization. In fact, there is no thought without generalization. In the words of Nietzsche, every concept arises from the equation of unequal things. Just as it is certain that one leaf is never totally the same as another, so it is certain that the concept leaf is formed by arbitrarily disregarding these individual differences and by forgetting the distinguishing aspects. Or, in the words of Jorge Luis Borges, to think is to forget a difference, to generalize, to abstract. So this is not the problem. The question then becomes, what separates admissible criteria of differentiation from inadmissible forms of discrimination? And this is a question that does not have a simple, all-embracing answer. American jurisprudence has developed the notion of suspect classifications. These classifications are those which have been identified as being most likely to lead to discrimination for historical reasons. Historically, they have been major sources of discrimination. Constitutional laws usually have or often have lists of such suspect classifications. An example of such lists may be found in Article 21, Paragraph 1 of the Charter of Fundamental Rights of the European Union. Any discrimination based on any ground, such as sex, race, color, ethnic or social origin, genetic features, language, religion or belief, political or any other opinion, membership of a national minority, property, birth, disability, age, or sexual orientation shall be prohibited. According to the doctrine of suspect classifications, closer scrutiny should be carried out on any attempt to differentiate based on these suspect classifications than on other types of differentiation. Any differentiation based on one or more of these classifications will be struck down unless an acceptable justification is provided, thereby setting what could be called as a presumption of wrongness. It is a given, of course, that differentiation based on stereotyping, on unsupported prejudice, is wrong. It amounts to discrimination. But what about so-called rational discrimination, such as differentiation based on accurate statistical findings? This is the type of differentiation that is most commonly used in the insurance business, where, for instance, a large number of empirical studies have shown that from a statistical perspective, women have a higher life expectancy than men, that women are more frequent users of health care services, or that serious traffic accidents are more often caused by men who nonetheless cause than by women, who nonetheless cause a higher number of minor traffic accidents. A recent decision of the Court of Justice of the European Union has held that, as from the 21st of December 2012, insurers may no longer charge men and women differently on the basis of scientific evidence that's statistically linked to their sex, effectively prohibiting the use of sex as a factor in the calculation of premiums and benefits for the purposes of insurance and related financial services. This is so throughout the European Union. This decision marks a sharp turn away from the traditional view, still enshrined in our national law, that insurers could do just about anything, could apply just about any risk assessment criterion, provided that they based it on sound, accurate, actuarial findings. The naivete behind the assumption that insurers' recourse to statistical and mathematical methods, given their scientific nature, would suffice to keep them out of harm's way was exposed. This is a most welcome outcome, but it is also important to question whether this judicial decision might have gone too far. So how do insurers go about their business? Insurance is a risk management tool aimed at reducing the negative impact of an uncertain future event by securing the financial means required to face it. When faced with such a risk, we may deal with it ourselves, for instance, by taking steps to eliminate it. We may try to reduce it, reducing the probability or the severity of the potential loss, or we may transfer the risk to an insurer in exchange for a fee, thereby choosing a certain smaller loss, the payment of a premium, over an uncertain, potentially much larger loss. At the root of the insurance business is the law of large numbers, which is a principle of probability theory, according to which this is Halley's mortality table, which is at the root of actuarial science, the science used by insurers to calculate, to assess risk. At the root of the insurance business is the law of large numbers, which is a principle of probability theory, according to which the larger the number of analogous exposure units independently exposed to loss, the closer the actual loss will be to the value of the expected loss. So, in a nutshell, whilst we cannot begin to predict if and when we are going to be involved in a car accident, it is possible, thanks to the law of large numbers, to estimate with a relatively small margin of error the number of car accidents that will occur in Lisbon in 2014. So we risk-averse individuals are happy to choose a certain smaller loss over a potentially much larger uncertain loss. But insurance have no reason to be risk-averse because their pool of clients is big enough for them to be able to calculate with an acceptable margin of error how high their aggregate loss will be, and may thus budget accordingly. This is quite simply how and why insurance as a business is lucrative and positive. So actuarial science draws on statistical analysis in order to measure each individual risk and price it accordingly. They draw on their hard data so as to conclude, for instance, that from a statistical point of view, women have a life, tend to have to live longer, to have a greater longevity than men, and that women use healthcare services more than men, and that serious traffic accidents are caused more often by men, whereas women cause a larger number of minor traffic accidents. These are conclusions based on accurate statistical findings. Sometimes, of course, statistical findings might be inaccurate. Let's not go into that. Let's assume that these are accurate. So the question then becomes, is this all? The two risk assessments factors most widely used in personal insurance are a person's age and a person's biological sex. Now, I will not go into the defined distinctions between sex, biological sex, and gender, because mostly, when I try to find out whether insurers use sex or gender, I don't get an answer. And basically, neither the law, a lot of times, neither does it distinguish it. So let's just stick with biological sex, although sometimes I'm sure that what is meant is rather gender. So these are the two most widely used factors: a person's age and biological sex. Why do they do it? Not because they're that interested in a person's age or sex. Their interest is in something different. It's, for instance, in our longevity. So if we had a chronometer stuck to our foreheads, telling us exactly how much time we would have on this earth, a dreadful prospect. If we had that, then insurers would not care about our age or sex. But failing that, they use these as surrogate factors, as instruments to reach an acceptable estimate of our average longevity. They do this because information is readily available. The first data that we have, the dawn of actuarial science happened with the mortality tables, with Halley's mortality tables in the 17th century, and they were about age and sex. We have the data from the past. It is very easy to ask our potential clients for their sex and age. They just tick a box or fill it in, and it's very easy to check if they have been truthful in their answers. So it makes sense from a financial perspective to use these factors. And yet they are both suspect classifications. So does this mean that personal insurance as we know it is doomed because of this recent decision of the European Court of Justice? Well, is accuracy all we should ask of statistical findings? That is the question. The court has answered in the negative, and let's check exactly why that should be. And for that, I would like to go back to a different context, that of racial discrimination in the United States, and examine two Supreme Court decisions, United States Supreme Court decisions, Brown versus Board of Education, a 1954 decision, and then a second one. This one, Brown, is a landmark decision. It has been called the most important decision in fighting racial prejudice. In this case, a number of, in a class action, the claimants were a number of parents of about 20 black children attending elementary schools in Kansas. They argued that racial segregation, allegedly providing separate but equal treatment of both white and black Americans, instead perpetuated an inferior treatment of black Americans. The Supreme Court unanimously held that even in segregated black and white schools, even if segregated black and white schools were proven to be of equal quality in all respects, even so, segregation itself was harmful to black Americans. Quoting this decision, we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. So this one, at least by today's standards, is an easy one. By the time the decision was reached, the scientific community had already rejected the supposedly scientific basis of segregation. So the issue here of accurate findings is apparently not at stake. But let's look at a second decision of the United States Supreme Court, Palmer versus Sirotti, 1984. In this case, there was a child, a white child, a little girl, whose parents got a divorce. She stayed with her mother. They were all white. The mother later on married a black man. And the father, the white father, asked for custody of the child because, allegedly, the child would suffer social stigmatization if left with an interracial couple. The court initially, the first instance court initially granted custody to the father, but the Supreme Court held, also unanimously, that this could not be. The Supreme Court accepted that the child would suffer social stigmatization and also accepted that both parents were otherwise equally fit parents. In any case, the court found that it was intolerable to use the argument of social stigmatization against the mother, because the reason for this social stigmatization was private prejudice of the community. And so, if they would allow this argument to work, they would undermine the principle in Brown. So, the judge, the first instance judge, had applied the criterion of deciding according to the best interests of the child. And the Supreme Court told the first instance court that, yes, this criterion should be applied, but the judge was forbidden to take into account private prejudice and the social stigmatization that the child would suffer. And now going back to Brown, actually, in Brown, there was also private suffering of all children. Brown gave rise to the end of segregation, and small children, black and white, suffered with this because a lot of southern states were full of turmoil, social demonstrations, even violence. In some places, education was interrupted for a while, and so children suffered. And the court, there were several attempts to delay the end of segregation with the argument that children were suffering, and the court just said, well, children are suffering that is unfortunate, but truly intolerable would be the alternative, would be to delay segregation on the basis that the society is prejudiced and so children suffer. And this is why this becomes relevant to our discussion, because sometimes the accuracy of results is not disputed, is accepted, and even so, those results cannot be used. Why? Because statistical analysis, by using past data to predict the future, can be used as an instrument to perpetuate past injustices in a way that is incompatible with the promotion of equality. So what we do in statistics and using probability theory is we look into the past and we project it into the future. If the past is tainted by discrimination, then we are helping to perpetuate such discrimination. So the first thing we must do is check whether these results that we have, these accurate results that we have, can be traced back to some past form of discrimination. And if the answer is yes, then we cannot use them. Take the case of male and female driving. It is not my place, it is not my role to check which concrete cases of discrimination, differentiation are or are not based on or can be tracked back to some past form of discrimination. That's the role of other social scientists. But it's not too difficult to imagine that somewhere there's discrimination. An image comes immediately to mind of women being driven literally by men for decades. And so, of course, I'm sure I could bet that there's something there. So that one is a goner. What about life expectancy? I am not so sure about that as I am about women's driving. Perhaps there is something there, perhaps there is not. But even there's another problem with accurate statistical findings, is that they do not tell us the whole truth. They tell us part of the truth. So there's another thing. A factual correlation does not establish cause and effect. Is the chosen factor the only or even a dominant feature? We have just seen why insurers use sex and age, because they're easier. But have they proven that these are the only or even the dominant factor influencing the results? Have they established cause and effect? So perhaps there's a link between sex and longevity, but what about the 50 other factors that might influence this and are not shown and not as widely used? This is another test that has to be put, and insurers would only be able to use this data, these accurate statistical findings, if this second test were passed. Having said all of this, the problem with the decision in the Nesta Session case, which is the name of the decision of the 2011 decision by the European Court, the Court of Justice of the European Union. The problem is that it treats suspect classifications as a convict without a trial. Now I'm in trouble. Okay. These suspect classifications should give rise to a presumption of wrongness, but the court simply decided that using sex as a factor is just forbidden in every situation. And when it comes to sex, maybe that's not too much of a burden to the insurance industry. But what if the same rationale is used with all other suspect classifications? For instance, age. Is age a dominant factor in assessing our longevity? Of course it is. Should age not pass the test of relevance to be used in determining our risk of death? I would say so. I do not have the data, but I could bet that age is a relevant factor in determining whether or not we will live 50 years. So I believe that the court, although giving us a much welcome move away from the previous wrong assumption, has led us into a dangerous path, because we are possibly throwing away the baby with the bathwater. Thank you.
Thank you very much for these really fascinating presentations. In the case of Miguel, if I can summarize, kind of demolishing many of the usual distinctions between social rights and civil and political rights, the between positive and negative, between rights that involve state expenditure and others that supposedly don't. This was a interesting demolishing. You end up with a dilemma, of course, but it's still, it was a fascinating presentation. And in the case of Margarida, I think what started as something that had to do with insurance turned out to be, at least in my mind, raising a lot of questions about the difference between truth and good, and also the difference, the way in which science, in particular social science, enters into the legal realm and into the courts, and how are we, and into legislation, and how are we as a community supposed to deal with that. So thank you very much for these two very interesting presentations. So I open for questions and for discussion.
Regarding your point on laws and insurance and using this type of indexes as a way to determine the risk, I would like to ask if you think about other types of laws that also use these types of indexes, like, for instance, the labor laws. Recently there's been a directive against age discrimination in work settings, but the same rationale that you do for insurances can apply to work settings in the same exact way.
Yes.
And I would like to ask, and also you know that we have an aging population, so these are really important issues to deal with, because the most part of the population will be older in the end. And another thought is, who are at the most risk when you think about the talk this morning? For instance, if you think about the cohorts born after, the young people now, even the children now, they might be at a higher risk than older people. So this is just a provocative.
Can we collect a couple of
Yes.
questions?
Well, thank you. Well, it was really good to hear you. It disrupts completely all the stereotypical ideas we have about lawyers and juridical scholars. So thank you. And very interesting presentations. I have, in fact, a question that could be differentiated for both, in a way. If I understood you correctly, Miguel, what you're defending, and it's also always very difficult to see you exactly defend something. You destroy a lot, but then it's difficult to see you propose something. But what you're defending, you're attacking neoliberal views and individualistic views of both types of rights, right? But it's interesting to see that you don't think this conundrum should be solved by the courts. What, in fact, you're saying, and this is, above all, a political problem, and should be dealt at a political level, even if politics uses the law. Is that it? Could you elaborate on that? Having said that, that political resolve that you're pointing to would be to take away the market from a lot of the areas where social rights could be enacted. And pertaining to your presentation, Margarida, well, the problem for me, again connecting with this first comment, question, whatever, it's stated in the title of your presentation, insurance business. This is a business, right? And so, what you're saying is that if this is to remain a business, somehow, even if not using the former system we had, which used all the suspect categories, But if this is to remain a business, you cannot pretend it's not. You cannot pretend that there's no differentiation of risk, right? And so I couldn't understand exactly what she proposed could be the right answer for this. And on the same line of thought, what could we say also about positive discriminations using those suspect categories? Thank you.
I think we can.
Okay, can I?
Okay.
Okay, I will just ask because, well, thank you for you both thanking me for inviting you. I really enjoyed your presentations, and I think that both of you proved very well that we should not have such a sharp idea of a division or a divide between kind of legal studies or the law and social science on the other hand. You were kind of both of you excellent social scientists in my view. So I'm going to make kind of more provocative questions that probably don't, that I think will fit into the spirit of the day. For Margarida, I was thinking how interesting it is, because you at some point of your presentation you said something like we must take action against, for instance, discrimination. And I was wondering, there is a movement here because firstly we need kind of legal mechanisms and the law to make a codification, even enforce rights or whatever. But they can be used or even manipulated in accordance with certain interests. In this case, business insurance, but it could be some other thing. And then again, we need law and courts to make sure that we can take action. Is that what you meant? So it's kind of it's really entangled the connection between, for instance, statistics and views of social differentiation and the law at the beginning, and for instance, and as a mechanism to impose certain conditions and again to put things right when they aren't. So what do you think of this, and how can we kind of combine the views of legal studies and of social sciences? And for Miguel, it's a more broad question, but I think it's on the agenda of Portuguese politics. What do you think, from your perspective and in your experience, of the possibilities or the consequences of, for instance, of a reform of the Portuguese constitution?
Very well. Miguel?
Thank you for your questions. First of all, concerning the question that was asked by Pedro, my point of view is to criticize the view that we can enforce social rights only by the courts. This is not. I think this is not possible, and this is an impoverishment of the social rights importance as a political matter, as part of a political culture. So, but there is a strong tendency in lawyers to see and to say that if social rights are not judicially enforceable, they are not rights at all. And this is what I question. I think there are negative effects of surrendering the enforcement of social rights only to the courts. And I give 3 examples that seem to me pretty precise, accurate. Concerning the revision of the Portuguese Constitution, I think it would be a grave error to revise, to alter, to transform the Portuguese Constitution. And this is an opinion that cyclically is introduced in the political discourse, and it shows that our politicians have no ideas and so they think they can resolve all problems by changing the constitution. It's not true, and even if we have amended the constitution, we still have to deal with principles, constitutional principles, and these are not subject to amendment or transformation. So I think it would not really be a good solution to our political and economic problems. What we have perhaps to change is or not to change, but at least to discuss, is the way we interpret the Constitution, and this is the really important question, is the interpretation of the Constitution, not changing the Constitution. Não sei se...
Okay, thank you. First of all, regarding the labor directive, and I generally believe that the same principles apply throughout, and not just in insurance. But I'm not prepared to say much more than that, because there are piles and piles of books written by labor lawyers, and I'm not one of them. And so I'll just stick to the general principles and move on. On what my proposal is regarding that insurance is a business and has to continue being a business, well, I believe that my proposal is that these three questions have to be asked. First, are the results accurate? Second, can they be traced to some past form of discrimination? And third, is this factor that is being used the only or a dominant factor in the cause and effect relationship with the outcome that we're interested in, or is it not? And only if these three questions are answered in the positive or in the negative, rather, should these results be usable. I'm not particularly. The fact that insurance is a business does not enable us to argue that these questions should not be asked. If it turned out that so many of the factors that are used are unusable, that insurance would no longer be viable, then it would no longer be viable, and that was the end of insurance. But I believe that this is not the case. Again, this is a conclusion that I am not able to draw as a scientist, because as a lawyer, I'm not going to analyze the empirical data and decide which ones have or have not been proven. That's not my job. But sticking to the criteria that should be used, I believe that in some cases, for instance, in the case of age, I could bet that in certain situations the test would be passed. And so I believe that there's a future for the business of insurance. And of course, insurers will lobby for legislation to be more favorable. That is also a given. But it's our job to make sure that the law and the court's decision are informed. And so previously we had legislation and decisions more favorable to insurers. Now I have brought here a decision that moves completely to the other side, and I am trying to defend that there's a middle ground that will make everyone happy, hopefully. But of course, this comes with scientific studies, social studies. We do our own legal studies. Other social sciences have to help us, because the concrete cases need the collaboration of sociologists, historians, etc. If we all do that, then the courts will have the data with which to decide which cases can and cannot be used. I think I have answered all of the questions.
Any more questions or comments? Go ahead.
I think that everything is a matter of business in the end, right? So it's, when you think about labor, for instance, and going back to the example, whether all the people to work or not after a certain age is also a matter of business, because the argument is that they are not productive anyway. So, and this goes back to the question about the Constitution. I think that principles are important to limit the business part. So it's a matter of should we discriminate or not based on age or gender, or and if we decide no, because as a matter of human rights it's not the way we want to act, then business has to go along with it. So, and this is, I don't know if this makes sense, but for me it makes sense, because I study age discrimination, and for if you read the European documents on this, the reason for not discriminating based on age is due to economic reasons, and not for once they say that it's about a human right. They never say this, and it's in all the constitutions all over the countries, but it's never a reason that they put forward. But for me, I think that is the main reason, and then the economic reason. And I don't think this is a naive view. It's a matter of seeing how we should guide our actions. Is it by business, or do we have a constitution with the way we want things to be done?
Professor.
Yeah, I mean, it's not too often, I mean, that social scientists have the opportunity, I mean, to listen to legal argumentation that you pointed out. I mean, this has been a very interesting afternoon. I have two comments, really, rather than questions. One is that I think, I mean, from looking at it from point of view of public policy, I mean, social policy and social rights, I think it is a problem when, and to the extent, I mean, that social rights are proclaimed and sort of located in the constitutional document, and then, I mean, there's no enforcement mechanisms. I mean, that has been the case in many countries. I mean, after World War II, I mean, several countries, I mean, Italy, for instance, I mean, had a whole catalogue of social rights, work and housing and all that, I mean, which never enforced, and I think that's a bit of a problem, and politicians, I think, should avoid, I mean, making such proclamations. On the other hand, I mean, I do think, I mean, that many social rights are actually enforceable and are being enforced, and not just minimum rights. I mean, if I don't get my pension at my legal pension age, I mean, I can legally claim, I mean, to get that, and that's a very important thing. Or also in rights to health care, I mean, I can bring up, I mean, if I've been not treated, or I've been maltreated by a hospital or by a doctor, I mean, this is something I can bring up. In general, I mean, I find, I mean, that large number of actually existing social rights and developed welfare states are enforceable, which is a good thing. Well, I'm not saying, I mean, that we're saying the opposite, but we try to frame the whole problematic a bit differently. But there is a problem, I think, I mean, from a political point of view and from a citizen point of view, if we have constitutional rights which are not enforceable, or not being enforced. Some rather, either one should avoid them, or one should see that they can be enforced. And I guess my point is that most of them can be enforced, in principle. The second comment, is about your argument about legislation of human equality and the insurance business, which is a very good case. I mean, because there are two principles, I mean, which run clearly against each other. I mean, one is what Max Weber would have called a Gesinnungsethik, a kind of normative system, I mean, of absolute principles, whatever the consequences. And the other one is what we call an ethical responsibility, which is focused on the consequences of normative decisions. Now, I was a bit perplexed by your wavering about the male and female longevity, because I think, I mean, it's an undisputable fact. So, I mean, no serious person is that women, unless there is an incredible discrimination against women or against girls, basically for children, women do live longer. And that, of course, I mean, does have, I mean, consequences for the insurance business. But the European Court apparently said, I mean, that doesn't matter. You know? And I don't think that's a very dangerous ground or potential dangerous ground. It's an example of the establishment of a normative hierarchy. Now, one could discuss, I mean, whether, I mean, how does that normative hierarchy should be established, and whether, I mean, sex differences, I mean, the fact that women are more gifted and more long-lived than men, I mean, that's something which we should ignore or something, or not. I mean, but and the interesting cases you mentioned from the American courts also illustrated this idea of a normative hierarchy. Suddenly, I mean, after 200 years of institutionalized racism, suddenly, I mean, we have a Supreme Court unanimously declaring that racist prejudice is intolerable. And that's, to some extent, I mean, that's not a legal issue or a legal problem. It's a normative development. And I guess we should see, I mean, the European Court, its decision prohibiting insurance businesses, I mean, to make any differentiation between men and women, again, as an interesting sort of normative development, which at least is incredibly interesting for, perhaps not for lawyers themselves, but for sociologists of law. Because it's something new. And historically, of course, I mean, it's even more interesting because, I mean, the difference between men and women. I mean, one of the oldest, most ancient, most universally recognized differences in human history. And now suddenly, European courts say, well, I mean, there are no differences. Or we agree to pretend, I mean, that there are no differences. Okay, fine. So, it's an extremely interesting decision, which creates a new kind of normative ground, not necessarily dangerous.
Thank you. Can you be very quick?
Very quick. I'm just wondering if the debate should be on, instead of about the place or status, or the hierarchical order of social rights, it's about the function. If you think of Rawls' theory of justice and principle of difference, the idea of what we see as social rights, as socioeconomic conditions, are subsidiary to political rights, and still do not lose the statute in terms of its implementation, that you don't have a problem with implementation, because that seems to be what you're trying to deal with, is how do we enforce these rights. But if you make them subsidiary, not subsidiary, as a primary condition for political rights, then you can still have a normative order, but still be fairly implementable, and you don't risk having political rights being diminished constitutionally as they are implemented. Is that clear?
Quite understand.
No, the idea is that you're trying to see what is the status of social rights versus political rights, right? Compared to political rights, because there's an issue, from what I understood from your presentation, of implementation, how these can be implemented or limited in legislation, of course. But maybe the question is, what should be the function of social rights, not necessarily the status of social rights with regards to political rights, because if you make them as a primary condition, as Rolf does, as a primary condition for the exercise of political rights, then the way they're implemented, you very much limit the ability to curtail those rights.
Can I ask you both to be relatively quick, if you can?
Okay. Mr. Hall, thank you. Thank you for your questions, and I think the way we really don't disagree. I think, and I will say this. In fact, the way you put the question of social rights makes clear that we have not abstract social rights. I have a social right to my pension. I have a social right not to be maltreated in the hospital, and these, I agree, are enforceable, judicially enforceable rights at the courts of law. And this is precisely because these specific rights you have mentioned are some are kind of negative rights. If the government doesn't pay my pension, is taking out of me. So I was not really saying that the social rights are not to be enforceable in courts. What I was saying is that this is not enough for social rights and for all dimensions of social rights. I think social rights are more demanding in terms of citizenship because they involve all the citizens, and they have to be there has to be a discussion of what is the content of those social rights, and this discussion, the citizens, I think, cannot be a part of this discussion. Concerning your question, I think Rawls distinguish two kinds of social rights. He, in fact, stated that there is what he calls a lexical priority of liberty rights over the rights specified by the different principle, the principle of difference and the principle of equality of opportunity. But he also says that the right to a decent minimum of existence is protected by the liberty rights, not by the principle of difference. And I think this is it's what he says. But let me be clear. I think there is no difference in terms of status of these two kinds of rights. I think we all need these. We all need social rights as civil rights, as political rights. So it is not possible to establish a legal category, with a precise legal regime. But this does not mean that in concrete, in cases that appear in courts, these types of rights put different problems, and they have to be differently solved, I think.
Thank you, Miguel.
Okay, and very quickly, I'm totally fine with the decision about a unisex insurance policies. The problem with the decision is that it's very short and blunt, and we have very many suspect classifications. And if they decide to apply the same criterion to all of them, then that will be the end of the insurance business. In fact, if we stick to sex, we are fine. We have been fine. This has been going on for 11 months now, and insurers just used it as an excuse to charge everyone a little bit more, and they're still living. So, but imagine this case. A 90-year-old man or woman goes into an insurance company and asks for an insurance policy, a 30-year long insurance policy, and demands to be charged the same premium as a 20-year-old. I would say that this is overdoing it. So these should be treated as suspect classifications, and in some cases, the presumption of wrongness will be set aside.
Thank you very much. We could discuss this more, but we are already about 30 minutes over schedule, but it wasn't. Thank you very much for your presentations and for your responses. Thanks for your participation.